Welcome to this special deep dive. It's brought to you by Sinorbit Academy, Sri Lanka, and we're focusing today on the EU treaties and really their significance for your University of London studies.
Exactly. And we really want to acknowledge the University of London for making these essential documents available to students. Just a reminder, this is for educational purposes only.
Absolutely. So today, we're not just listing treaties. We're trying to unpack how you can effectively study this material, how to approach it to really help you prepare for your exam. So good luck to all of you listening.
Yeah, good luck. And look, we're covering a lot of ground here. The source material takes us right from the EU's origins after World War II, all the way through to recent things like Brexit and, well, the current crises everyone's talking about.
So we'll be looking at those key treaties, Rome, Maastricht, Lisbon, all the big ones, and how they shaped the EU's legal system.
That's right. And our mission, really, is to give you a structured way to understand it all. We'll focus on the key concepts you need, those important case names you know, the ones you need to remember, and what they actually mean. We want this stuff to stick for your exams.
We're looking at the why behind it all, aren't we? Not just the what, how these treaties evolved.
Precisely. The context is everything.
Okay, so let's dive right in. Foundations first. To really get a grip on this, we need to go back to just after World War II. Europe's in ruins. There's this huge desire for peace, for economic stability. That backdrop is, well, it's fundamental, isn't it?
It absolutely is. And what's quite striking is how quickly ideas for working together started popping up. One really key moment, and definitely one for you to remember for exams, is the Schuman Declaration.
1950, right? Robert Schuman.
That's the one, the French foreign minister. He proposed pooling French and German coal and steel under a common authority. Now, why was that so revolutionary?
Because coal and steel were war materials.
Exactly, the raw ingredients for weapons. The thinking was, if you control them jointly, it makes war between France and Germany, materially impossible. It was economic, sure, but deeply political, too, aimed at lasting peace. And they invited other European countries to join in.
And that declaration led pretty directly to the Treaty of Paris in 51. Tell us about the ECSC, the European Coal and Steel Community. What made that different? That's a key point for students, I think.
Yes, the Treaty of Paris. Signed by the six founders, France, Germany, Italy, and the Benelux countries, Belgium, Netherlands, Luxembourg. It set up the ECSC, the main goal, a common market just for coal and steel.
Okay, specific to those resources.
Right. But here's the really crucial part for your studies. The ECSC created supranational institutions, a high authority, an assembly, a council, a court. These bodies had real power above the member states, binding decisions. This idea, supranationalism, was a massive first step. Keep that word supranationalism firmly in mind.
Supranationalism, got it. Now, the UK, they weren't involved right at the start, were they? Seems a bit odd looking back.
It is interesting. No, they weren't. The UK government back then had, well, serious doubts about the whole supranational thing, worries about national sovereignty.
Ah, sovereignty, a recurring theme.
Indeed. So, they chose not to join the ECSC. It's also worth remembering that another plan for a European defense community, which the UK also sat out of, failed later on. French opposition, that time. It just shows that this whole integration path wasn't exactly smooth sailing.
So despite that defense hiccup, the drive for more integration didn't just disappear. How did we get from coal and steel to something much broader, like the EEC?
Well, even with the defense community failing, those same six ECSC members met again in Messina, Italy, in 1955. That meeting led to something called the Spake Report.
Okay, the Spake Report.
And that report basically laid out the plans for two new communities. One was the European Atomic Energy Community, Euratom, focusing on peaceful nuclear energy development.
Yeah.
And the other, the big one for your studies, was the European Economic Community, the EEC.
Right, the EEC, a huge expansion of the idea.
Definitely. Moving way beyond just coal and steel.
Okay, and just quickly, for students listening, it's really important we don't mix up the EEC and later the EU with the Council of Europe, right? They sound similar, but they're totally different beasts.
Oh, absolutely crucial distinction. The Council of Europe is much older, set back in 1949. It's a separate international organization based in Strasbourg. Its job is promoting democracy, human rights, rule of law.
And they're responsible for the European Convention on Human Rights, the ECHR.
Exactly. The ECHR, drafted in 1950, and the European Court of Human Rights, the ECTHR in Strasbourg. That's all Council of Europe territory. Completely separate from the EU's institutions and the Court of Justice of the EU in Luxembourg.
But there is a connection, or an intended one.
There is. You should remember Article 6, Paragraph 2 of the Treaty on European Union, the TEU, as amended by Lisbon. It actually says the EU will accede to the ECHR. So there's a planned link there for the future, but for now, and for your studies generally, keep them separate in your mind.
Okay, clear distinction made. So that sets the scene nicely. Let's really get into the Treaty of Rome now. 1957, the birth of the EEC. For exam purposes, what were the absolute core goals here?
The number one aim, without a doubt, was establishing a common market among the member states. Remember, the context post-war reconstruction was vital. A common market was seen as the engine for rebuilding economies, creating interdependence, boosting wealth, growth, productivity.
And things like food shortages during the war also played a part.
Yes, that memory definitely pushed the idea of a common agricultural policy too. But the central pillar, the headline for the Treaty of Rome, is common market.
And that term common market, we often hear internal market or single market used now. Could you just clarify for listeners, are they basically the same thing in practice?
Yeah, largely interchangeable, though internal market is probably the more common term legally these days.
Mhm.
The first big step to create it was getting rid of customs duties between the member states.
So no tariffs on goods crossing borders inside the EEC.
Exactly. And alongside that, they set up a common customs tariff, a single set of duties for goods coming in from outside the EEC. So once goods from, say, the U.S. paid the tariff at Rotterdam, they could then move freely throughout the whole community without paying more duties.
Okay, so for exams, no internal tariffs, common external tariff. That's the foundation.
That's the bedrock, yes.
But creating a true common market, it's got to be more than just tariffs, surely.
Oh, much more. The goal was to scrap all the barriers to goods moving freely, fiscal ones, physical border checks, different technical standards, you name it. But even beyond goods, the Treaty of Rome guaranteed the famous four freedoms.
Ah, yes, the four freedoms. Definitely need to know these.
Absolutely critical. The free movement of goods, the free movement of persons, workers, and establishment, the free movement of services, and the free movement of capital. Say them with me again. Goods, persons, services, capital. Burn those into your memory.
Goods, persons, services, capital. The four freedoms. Got it.
And what other key policies did Rome establish to make this market work? These must be important, too, for understanding the initial scope.
Well, it laid the groundwork for several vital areas. A competition policy, now Articles 101 to 109 in the TFEU, to stop things like cartels or monopolies messing up the market.
Right, keeping things fair.
Exactly. And a ban on state aids governments giving unfair advantages to their own companies. Plus, it set up a common commercial policy for external trade, the common agricultural policy, or a KP, a common transport policy, and eventually a common fisheries policy. So remember those initial common policies, key tools for building that common market.
It sounds incredibly ambitious right from the start. How did they actually plan to make it happen? Was it all about new laws?
Well, the initial idea, I think, was that harmonization would do a lot of the heavy lifting, member states agreeing on common standards through new EU laws, secondary legislation. But getting agreement proved, tricky, slow.
As you might expect with 6 different countries. Quite. So what happened was the European Court of Justice, the ECJ, became incredibly important. Often, its rulings pushed for deregulation, striking down national rules that got in the way of free movement. So you had this interplay, some harmonization, but also the court clearing away obstacles. The initial plan also looked towards eventual fiscal and social policy harmonization and even monetary union way down the line.
So the ECJ, now the CJEU,
What?
let's talk institutions. The ECSC had its own, and Rome built on that. Understanding the setup is key.
Yes. ECSC in 51 had its 4 bodies. The Treaty of Rome basically copied that model. It rested a commission for the EC and another for Euratom alongside the ECSC's high authority. The other institutions, the Council of Ministers, not just the Council, the European Assembly, later Parliament, and the European Court of Justice, they just had their powers extended to cover all 3 communities.
So 3 executives initially, but 1 council, 1 parliament, 1 court.
That's right. A bit complicated, which is why the 1965 merger treaty is important to remember. It tidied things up by merging the 3 executives into a single commission and merging the councils into a single council. Much simpler. 1 commission, 1 council from 65 onwards.
Streamlining. Okay. And the overall vibe, the spirit of the EEC in the treaty itself. What were the guiding principles mentioned?
If you look at the preamble, it talks about laying foundations for an ever closer union among the peoples of Europe and ensuring economic and social progress, aiming for constant improvements of the living and working conditions.
So ideals were there, but the focus was practical.
Very much so initially. Article 2 of the original treaty spells it out. establish a common market to promote harmonious development of economic activities, balanced expansion, increased stability, a raised standard of living, and closer relations between the states. The primary engine was economic integration. Keep that economic focus front and center for the early years.
And you mentioned the treaty was a traité cadre, a framework treaty. What does that actually mean for how the EU developed, for students trying to understand the process?
Good point. It means the Treaty of Rome set out the big picture, the main goals and principles, but it deliberately left a lot of the detail to be filled in later. It relied on the case law of the European Court of Justice and on secondary legislation, directives and regulations passed by the institutions to actually build the common market and make it work.
So it wasn't a complete rulebook from day one.
Not at all. Think of it like a blueprint that needed architects and builders, the court, and the legislators to finish the job. This gave it flexibility, allowed it to adapt, but it also meant the ECJ had a massive role in shaping how EU law actually developed. A very powerful court.
Okay, foundations established. Now the evolution. How did we get from the EEC to the EU we have today? We need to hit the key treaty changes chronologically, I think, to help people remember them for exams.
Right, it's a story of steps, sometimes leaps. We already mentioned the 1965 merger treaty simplifying the institutions. Single commission, single council. That's an early one to nail down.
And then soon after, the Luxembourg Accords in '66. That sounds less like integration. What was its significance, particularly for voting? Seemed like a step backwards from supranationalism.
It was in many ways. The Luxembourg Accords, often called the Luxembourg Compromise, came about after France, under de Gaulle, basically boycotted the council meetings. The issue was the planned move from unanimity everyone has to agree to, qualified majority voting, or QMV, in more areas.
France didn't want to lose its veto.
Exactly. The compromise, though not strictly legally binding, established a political understanding that if a member state felt its important national interests were at stake, the Council would try and find a solution everyone could accept. In practice, it meant the veto power was preserved, even where QMV was supposed to apply.
Leading to
Often, stagnation. Decision-making slowed right down because any one country could block things. Definitely note that for your exams, the Luxembourg Compromise often hampered progress. It really shows that tension between national interests and collective EU action.
Okay, a significant political reality. Then we had the budgetary treaties in the 70s, 1970 and 1975. What did they do?
These were really important for the community's financial autonomy. They shifted funding away from direct contributions from member states towards the community having its own resources, things like customs duties and a share of VAT.
So its own money, not just handouts.
Pretty much. And crucially, these treaties also boosted the budgetary powers of the European Parliament, giving it more say over how the money was spent. The 1975 treaty also set up the Court of Auditors to scrutinize spending. So key takeaways: own resources and more power for the Parliament over the budget.
And around this time, the community started getting bigger. Enlargements.
Yes, the first big wave was in 1973. The UK, Denmark, and Ireland joined, then Greece in 1981, and then Spain and Portugal in 1986. Just knowing the sequence helps show how the community was expanding its reach.
And another milestone for the Parliament in 1979 direct elections. Why was that such a big deal?
Huge deal for democratic legitimacy. Before '79, MEPs were appointed from national parliaments. Direct elections meant citizens voted for their MEPs directly. This gave the Parliament a much stronger mandate, made it directly accountable to the people. It's a really key step in its journey from just being consulted to actually making laws.
Okay, building legitimacy. Then we arrive at the Single European Act, the SEA, in 1986. This feels like a major turning point towards the modern EU. What were the absolute must-know achievements?
The ECA was a massive revision. Its driving force was the push to finally complete the single market by the target date of 1992, removing all those remaining barriers, physical, fiscal, technical.
And how did it plan to achieve that, given the Luxembourg Compromise problems?
The key mechanism was the introduction, or rather the significant expansion, of qualified majority voting, QMV. Specifically, under what's now Article 114 TFEU, measures needed to create the single market could be passed by QMV. This was the big deadlock breaker. It allowed progress even if one or two states weren't happy. Remember, SEA means more QMV, which means the single market actually happened.
So QMV was the engine for the single market. That's a critical link.
Absolutely critical. The SEA also brought in the cooperation procedure, which gave the Parliament more say, though not quite full co-decision yet. And it formally expanded the community's powers into new areas: R&D, regional development, cohesion, environmental policy. It also paved the way for the Court of First Instance, now the General Court, to help the ECJ with its workload, and it gave formal recognition to the European Council, the meetings of heads of state or government.
So the SEA, single market completion, QMV boost, stronger parliament, new policy areas, really packed a punch.
It really did. And it set the stage perfectly for the next giant leap.
Which was the 1992 Treaty on European Union Maastricht, the treaty that actually created the EU itself. This one is absolutely fundamental, isn't it?
Oh, completely. Maastricht was a watershed. It formally created the European Union as we know it, based on a famous or perhaps infamous three-pillar structure.
Okay, the three pillars, what were they?
Pillar 1 was the existing European Community, EC, basically the old EEC structure, but slightly updated. This was the supranational pillar. Pillars 2 and 3 were new: Common Foreign and Security Policy, CFSP, and Justice and Home Affairs, JHA. And this is crucial for your studies, these two new pillars were largely intergovernmental. Decision-making was different, more reliant on cooperation between governments, less supranational power. Remember that pillar structure and the difference between them.
And Maastricht wasn't plain sailing either, was it? Ratification had some bumps.
Definitely not. There was a famous no vote in Denmark's first referendum, which needed some opt-outs and guarantees before a second yes vote, and there were major legal challenges in national courts too. In the UK, you had the RV Secretary of State for Foreign and Commonwealth Affairs ex parte Rees-Mogg case, questioning the government's power to ratify. And in Germany, the Brenner v. European Union Treaty case before their constitutional court raised deep questions about sovereignty and democracy. These cases really highlight how national constitutions grapple with EU integration.
So what were the really big changes Maastricht made within that first pillar, the old EEC treaty? What new ideas came in?
Several massive ones. It introduced citizenship of the Union, giving EU nationals specific rights like free movement and consular protection. It formally introduced the principle of subsidiarity, the idea that decisions should be taken as close to the citizen as possible, so the EU should only act if objectives can't be better achieved by the member states.
Subsidiarity, another key concept.
Huge one. Then Economic and Monetary Union, EMU, was set out as a key objective, outlining the path towards the single currency, the euro. The EU's powers, its competences, were expanded again: environment, education, consumer protection, public health, culture. The list grew.
And the parliament, did it get another boost?
A massive one. Maastricht introduced the co-decision procedure. This, for the first time, made the European Parliament a genuine co-legislator alongside the Council in many important areas. It could now block legislation. It also got the right to request the Commission propose legislation, the power to appoint the European Ombudsman, and the whole Commission needed Parliament's vote of approval. Co-decision is a game-changer for the Parliament's power.
So Maastricht, EU created three pillars: citizenship, subsidiarity, EMU path, more competences, and critically, Parliament becomes a co-legislator via co-decision.
That's a pretty solid summary. You can really see the Parliament's power growing treaty by treaty.
A clear trend. And after Maastricht, more accessions.
Yep. In 1995, Finland, Sweden, and Austria joined. The EU kept expanding.
Okay, next up, the 1999 Treaty of Amsterdam. What are the key takeaways from that one for exam revision?
Amsterdam continued the tidying up and evolution. It amended the EC Treaty again, adding new objectives like promoting equality, sustainable development, environmental protection. It also simplified and extended the scope of that co-decision procedure even further, strengthening the Parliament again.
More power to the Parliament.
Consistently.
Yeah.
It introduced a really important new legal basis, Article 13 of the EC Treaty, then allowing the EU to combat discrimination on grounds like race, religion, disability, age, sexual orientation, a major step for fundamental rights. Amsterdam also formally brought in enhanced cooperation.
Enhanced cooperation, what's that?
It's a mechanism allowing a group of willing member states to integrate more closely in a specific area, even if others don't want to join in. Sometimes called variable geometry or a multi-speed Europe, it adds flexibility. Amsterdam also boosted the Parliament's role in appointing the Commission president and put more emphasis on transparency and the core values of liberty, democracy, and human rights, referencing them in the TEU.
Okay, so Amsterdam. Refining co-decision, tackling discrimination, allowing enhanced cooperation, more transparency, and rights focus. Then came the Treaty of Nice in 2003. That one was mainly about getting ready for the big enlargement, wasn't it?
Exactly. And NICE was almost entirely focused on institutional reforms needed to cope with the massive 2004 enlargement, when 10 countries, mostly from Central and Eastern Europe, were set to join.
Making the EU work with 25 members instead of 15.
Precisely. So NICE rejigged the number of commissioners per country, reallocated seats in the parliament, changed the voting weights in the council, all quite technical but essential for a much bigger EU. It also made it easier for the parliament to bring cases to the ECJ, tweaked the court system to handle more cases, and made enhanced cooperation slightly easier to trigger. It was functional preparation work mostly.
And that 2004 enlargement was huge, wasn't it? Really changed the face of the EU. Estonia, Latvia, Lithuania, Poland, Czech Republic, Slovakia, Hungary, Slovenia, Malta, Cyprus.
Transformative. But it was followed quite quickly by a setback, the rejection of the draft constitutional treaty.
Ah, yes, the attempt to create a single EU constitution.
That's right. It aimed to simplify everything, merge all the treaties into one text. Signed by governments in 2004, but then rejected in referendums in France and the Netherlands in 2005. That caused a major pause, a period of reflection. Showed the limits of how fast or how far integration could go without public backing.
And out of that reflection came the Treaty of Lisbon, signed in 2007, force in 2009. How did that differ from the failed constitution, and what are its key features for students?
Lisbon was essentially Plan B. It salvaged many of the substantive reforms from the constitutional treaty, but dropped the constitutional packaging. It wasn't presented as a new constitution, but as amendments to the existing treaties, the TEU and the EC Treaty, which got renamed the Treaty on the Functioning of the European Union, the TFEU.
So kick the substance, lose the symbols?
Largely, yes. Things like calling the High Representative a Minister for Foreign Affairs were dropped. EU symbols like the flag and anthem weren't in the treaty text itself. There's no explicit clause stating EU law supremacy, though a declaration attached points to the existing CJEU case law confirming it. And, very importantly, Lisbon abolished the three-pillar structure for Maastricht.
Ah, so no more pillars, just the EU.
Just the EU, acting under the rules set out in the TEU and the TFEU. It streamlined the legal framework significantly.
Okay, structure simplified. What about the big substantive changes Lisbon brought in? What do students absolutely need to know?
Right. Key Lisbon changes. A permanent full-time president of the European Council, the creation of the High Representative for Foreign Affairs and Security Policy is also a vice president of the Commission, bridging institutions, a massive extension of qualified majority voting in the Council, and the ordinary legislative procedure, the new name for co-decision, with the Parliament to many, many more areas.
So even more QMV, even more power for the Parliament.
Definitely. Lisbon also formally categorized EU competences, exclusive, shared, supporting, clarifying who does what. It gave the Charter of Fundamental Rights the same legal value as the treaties, making it legally binding. It increased the role for national parliaments with things like the yellow card subsidiarity check. It gave the EU as a whole legal personality, allowing it to sign international treaties. It reaffirmed the goal of acceding to the ECHR. And crucially, for anyone studying cases or articles, it involved a complete renumbering of the treaty articles. Always check if you're using pre- or post-Lisbon numbers.
That renumbering catches everyone out. So, Lisbon. No pillars, more QME parliament power, binding charter, defined competences, legal personality, new article numbers, a major overhaul.
A very significant treaty, yes. Tidied up a lot, consolidated trends.
Now, moving slightly beyond those core constitutional treaties, there's the Fiscal Compact Treaty from 2012. What prompted that and what did it do? Mainly for Eurozone countries.
Yes, the Fiscal Compact, or Treaty on Stability, Coordination, and Governance in the EMU, was a direct result of the sovereign debt crisis that started around 2010. It aimed to enforce stricter budgetary discipline, mainly on Eurozone members, but others could opt in.
Stricter budget rules.
Essentially, yes. It requires participating states to have rules in their national law, limiting structural deficits, the so-called balanced budget rule or debt brake. It also strengthened the EU's excessive deficit procedure and even allowed the CJEU to impose fines on countries not complying with the budget rules following a case brought by other member states.
And it linked into bailout funds.
Crucially, yes. Ratifying the Fiscal Compact was often a condition for receiving financial assistance from the new Permanent Bailout Fund, the European Stability Mechanism, or ESM. The legality of the ESM itself was challenged but upheld by the CJEU in the important case C3704 Pringle v. Ireland. The court found it compatible with EU law, allowing this key crisis-fighting tool.
So the fiscal compact and ESM were tools forged in that euro crisis. And looking ahead, despite everything, enlargement is still on the agenda.
It is, yes. The geopolitical situation, particularly the war in Ukraine, has given it new momentum. Several countries now have official candidate status. Albania, Bosnia and Herzegovina, Georgia, Moldova, Montenegro, North Macedonia, Serbia, Turkey, and Ukraine. Kosovo is a potential candidate too. So the EU's potential borders are still very much in flux.
Okay, now, we absolutely have to talk about Brexit. Section 2.5 in the source material. Can you walk us through the key legal points of the UK's exit, thinking about what's important for understanding the treaty framework?
Right, Brexit. A huge event for both the UK and the EU. It all started legally with the June 2016 referendum result. The mechanism for leaving is Article 50 of the Treaty on European Union. It sets out the process. A member state notifies the European Council of its intention to withdraw. Then there's a period, typically 2 years unless extended, to negotiate a withdrawal agreement. If no agreement is reached, exit happens automatically after the 2 years.
And Article 50 mentions withdrawing in accordance with its own constitutional requirements. That became a big issue in the UK, didn't it?
It certainly did. It led directly to the landmark UK Supreme Court case, Miller v. Secretary of State for exiting the European Union. The court ruled the government couldn't trigger Article 50 using just ancient prerogative powers, because leaving the EU would fundamentally change UK law and remove rights citizens had under EU law. Parliamentary approval was needed.
So Parliament had to authorize triggering Article 50.
Yes, which it did. The UK then formally notified its intention to leave on 29 March 2017. Another key case to remember, this time from the CJEU, is case C62118 Whiteman. This confirmed that a member state could unilaterally revoke its Article 50 notification, change its mind, as long as it did so clearly, unconditionally, before withdrawal took effect and following its own constitutional procedures.
So legally, the door wasn't completely shut until exit day itself. Once the decision was final, though, how did the UK manage the huge legal task of untangling its laws?
The main tool was the EU Withdrawal Act 2018, sometimes called the Great Repeal Bill initially. Its primary job was to repeal the European Communities Act 1972, the law that brought the UK into the EEC and gave EU law effect in the UK. But to avoid a legal black hole, it also converted the bulk of existing EU law as it stood on exit day into UK domestic law, creating this new category of retained EU law.
So EU law didn't just vanish overnight.
No. Much of it was copied across, but the Act also gave UK ministers powers to amend or remove bits of this retained law over time. It was a complex way to manage the transition.
And eventually, after much negotiation, a withdrawal agreement and then a trade and cooperation agreement, TCA, were agreed. What's the key thing to understand about the TCA's legal nature? How does it compare to being an EU member?
The TTA, which governs the relationship now, is fundamentally different. It's a classic international agreement between two separate parties, the EU and the UK. Crucially, unlike EU law, it generally doesn't create rights that individuals can directly rely on in national courts.
So no direct effect, mostly.
Largely, no. It's mainly a free trade agreement, zero tariffs, zero quotas on goods if they meet the rules of origin. It covers some other things like security cooperation and has a governance structure, a partnership council to manage the agreement. But, and this is vital, the CJEU has no role in governing or settling disputes under the TCA. Disputes go to arbitration panels.
A completely different system to EU membership.
Entirely. And there are mechanisms for rebalancing if significant divergences emerge. And the whole thing can be reviewed every 5 years or terminated with 12 months' notice. It's a standard international treaty, not EU membership light.
And one of the most difficult parts was the Irish border issue, leading to the Northern Ireland Protocol, now amended by the Windsor Framework. What was the goal there, and what should students know about its status?
The goal was incredibly difficult. Protect the Good Friday Agreement, avoid a hard land border on the island of Ireland, and protect the integrity of the EU's single market, all after the UK left the single market and customs union. The original protocol effectively kept Northern Ireland aligned with EU single market rules for goods and applied the EU's customs code, requiring checks on goods coming from Great Britain into Northern Ireland.
Which caused significant political problems.
It did. The Windsor Framework, agreed in 2023, tries to smooth this out. It introduces things like green lanes for goods staying within NI with fewer checks, red lanes for goods moving on to the EU. It allows UK standards for many goods sold only in NI. It also created the Stormont Break, a mechanism allowing the NI Assembly, in specific circumstances, to object to new EU single market rules applying an NI, potentially leading the UK government to veto them.
But does EU law still apply in NI under the framework? And what about the CJE?
Yes, a significant body of EU law related to goods, customs, state aid, VAT, etc., still applies in Northern Ireland to make this work. And consequently, the CGEU still has jurisdiction to interpret those specific EU laws as they apply in Northern Ireland. So while the rest of the UK is outside the CJEU's direct reach mostly, Northern Ireland remains in a unique position, partly under its jurisdiction for protocol framework matters.
A very complex arrangement. And even outside the NI context, there's still some legal interaction post-Brexit. The ties aren't totally cut.
Not entirely, no. Yeah. The CJEU is still finishing cases involving the UK that started before the transition period ended. The Commission also has a 4-year window after the transition ended, so until end of 2024, to bring infringement cases against the UK for breaches of EU law during the transition period. And as we just said, there's the ongoing CJEU role under the Windsor Framework.
Any recent examples of the CJE ruling on the UK?
Yes. A notable one is Case C692280 Commission v UK. The CJEU found the UK failed to comply with rules on fuel markers and imposed a hefty lump sum and penalty payments. Interestingly, when calculating the penalty, the court looked at the UK's overall GDP, its ability to pay, even though it's no longer a member. It shows the CJEU can still impose significant sanctions for past breaches or ongoing specific obligations.
Okay, so Brexit remains legally complex. Finally, the source material looks at multiple crises, a new beginnings, COVID, and the Ukraine war. How have these massive events tested and maybe changed the EU even without new treaties?
They've been huge tests, definitely. And they've shown the EU can sometimes act decisively and integrate further using the existing treaty framework, even if it stretches it. The COVID-19 pandemic initially saw borders slam shut, seemingly undermining free movement, but it also triggered unprecedented solidarity.
Like the recovery fund.
Exactly. The EU activated its civil protection mechanism, did joint procurement of vaccines, and crucially created the massive next-generation EU recovery fund, hundreds of billions of euros financed by common borrowing. That was legally based on existing articles like 122, 311, 312, 175 TFEU, but it was a huge political step. It also spurred moves towards a health union, setting up bodies like HERA, the Health Emergency Preparedness and Response Authority.
So, crisis-driving integration in health, and the Ukraine war, an even bigger geopolitical shock.
Absolutely. The EU's response has been remarkably united and robust, especially on sanctions. Multiple packages targeting Russia's economy, banks, individuals. These are adopted under Article 29 TEU in the CFSP pillar, usually requiring unanimity.
And are CFSP decisions reviewable by the courts?
Generally, CFSP is outside the CJE's jurisdiction. Articles 24 and 275 TFEU say that. However, the court has carved out an exception for reviewing the legality of sanctions, targeting individuals or companies, checking they respect fundamental rights and have a sufficient factual basis. Cases like Rosneft and, more recently, Zubitsky and Prigozhin show the court scrutinizing these CFSP decisions quite carefully.
So some judicial oversight even in foreign policy. What else has the EU done?
It used the European Peace Facility, funded outside the main EU budget, to reimburse member states for sending military aid to Ukraine, a major step. It activated the Temporary Protection Directive for the first time ever, giving millions of Ukrainian refugees rights to reside, work, access housing, and healthcare across the EU. It's also accelerated the green energy transition and, as we mentioned, potentially given new impetus to enlargement.
So these crises are forcing the EU to act, perhaps in ways not fully anticipated by the treaties.
You could say that. It underlines the point made in the conclusion of the source material, quoting the Schuman Declaration again. Quote, Europe will not be made all at once, or according to a single plan. It will be built through concrete achievements which first create a de facto solidarity. That seems just as true today facing these crises as it was in 1950. The EU continues to be built through responding to concrete challenges.
That's a great place to pause and reflect. So just to wrap up this deep dive, we've covered a huge amount: the post-war context, the founding Treaty of Rome and its core ideas like the common market and four freedoms, the whole evolution through key treaties like the SEA, Maastricht, Amsterdam, Lisbon, highlighting things like QMV and the rise of the parliament.
We've also tackled the immense legal and political challenge of Brexit, looking at Article 50, the key court cases like Miller and Whiteman, the TCA, and the ongoing complexities of the Northern Ireland situation under the Windsor Framework.
And finally, how recent crises like COVID and the Ukraine war are pushing the EU to adapt and act, sometimes testing the limits of the current treaties. Understanding this whole journey, the why behind each step, the key concepts, the crucial case law is absolutely vital for your studies and, of course, for doing well in your exams.
We really hope this structured walkthrough has helped solidify some of those key elements and given you a clearer map of the territory. Remember those key terms, those treaty names, those fundamental cases.
Definitely. And don't stop here. Use this as a springboard to go back to your readings. Explore the areas that grabbed your attention. Really dig into the details. Think critically about the implications of each development.
And perhaps leave you with a final thought to ponder as you continue studying. Considering this whole journey, the constant adaptation, the crises, what do you think are the biggest challenges and maybe the biggest opportunities facing the European Union in the years ahead?
Something to think about. Thank you so much for joining us for this deep dive into the EU treaties. Remember, this discussion, based on materials kindly made available by the University of London for educational purposes only, was brought to you by Sinorbit Academy, Sri Lanka. We wish you the very, very best in your upcoming exams.